I'm seeing some severe whiplash out of Washington right now. In Texas, the Department of Justice under Pamela Bondi is doing everything it can to keep the National Firearms Act alive, even after the One Big Beautiful Bill set most NFA taxes to zero. And groups like Gun Owners of America and the Silencer Shop Foundation argued that a tax law without a tax has no constitutional leg left to stand on. DOJ's latest move is to abandon the old taxing power justification and fall back on the Commerce Clause and the Necessary and Proper Clause to protect what gun owners see as a federal registry. But up at the Supreme Court, in Wolford v. Lopez, that same DOJ is suddenly standing shoulder to shoulder with gun owners, telling the justices that Hawaii's vampire rule default ban on carry-on private property violates the Bruen text, history, and tradition standard. All right, let's start by grounding this in what actually changed on paper, because the headlines and the memes honestly hide the most important part of this story. First, a quick refresher on the National Firearms Act. The NFA has been around since 1934. It's the law that treats certain guns and accessories as a special, restricted category machine guns, short-barreled rifles, short-barreled shotguns, suppressors, and a handful of oddball any other weapons. For almost 90 years, the federal government has justified that whole system by pointing to one thing: the tax. You pay a $200 tax, you register the item, you submit fingerprints and photos, and they tell you, relax, this is just Congress using its taxing power. That story only makes sense if the tax is real, and that's where the One Big Beautiful Bill Act comes in. Congress passed H.R. 1 nicknamed the One Big Beautiful Bill Act as a massive budget and tax package. Buried in that bill is a section that targets the NFA. It doesn't repeal the NFA, it doesn't erase the registry. What it does is slash the $200 tax on most NFA items down to $0. Suppressors, short-barreled rifles, short-barreled shotguns, most any other weapons, those are now, at least on paper, tax-free transfers once the effective date kicks in. But here's the catch: the forms didn't go away. The fingerprints didn't go away. The registration system did not go away. Congress essentially said, we're going to leave the federal registry in place, but we're no longer going to collect money on these items. So functionally, for a huge chunk of the NFA, the tax law part is gone, and what you're left with is a pure federal tracking system with criminal penalties wrapped around it. From a constitutional perspective, that's a big deal. For decades, when courts looked at the NFA, they leaned on the idea that this was a tax scheme first and a gun control scheme second. Now, at least for most items, the revenue has been pulled out of the equation. There's no money coming in on those transfers. And that raises a simple but very important question: if the tax is zero, can the federal government still lean on its taxing power to justify this whole framework? Gun rights lawyers have been waiting their entire careers for that question to stop being theoretical. Thanks to this bill, it is no longer theoretical. It's live right now in a federal courtroom in Texas. That brings us to what's being called the One Big Beautiful lawsuit. Shortly after the tax cut was signed into law, a coalition led by the Silencer Shop Foundation, with Gun Owners of America and other partners, filed suit in the Northern District of Texas. The case is styled Silencer Shop Foundation v. Bureau of Alcohol, Tobacco, Firearms, and Explosives. On the surface, it looks like yet another NFA case, but the theory behind it is very different from the usual challenges we've seen to individual rules or agency interpretations. The plaintiffs are making a straightforward claim when Congress zeroed out the tax on suppressors, SBRs, SBS, and other covered NFA items. It knocked the legs out from under the NFA's old constitutional justification. You can't call something a tax law if no revenue is being raised. And if it isn't really about revenue anymore, then the federal government can't hide behind the taxing power and pretend this is just about dollars and cents. Under that view, what's left of the NFA for those items is a nationwide gun registry enforced with criminal penalties. It tells law-abiding citizens, you can have certain guns and accessories, but only if you put your name on a federal list, ask permission, wait months, and accept that you can be prosecuted if a single piece of paperwork is wrong. That looks a lot less like a tax and a lot more like a direct regulation of arms that ordinary Americans have a right to keep and bear. Now, that's the gun rights side of the story. What did the government do in response? This is where the Department of Justice under Attorney General Pamela Bondi made a very important, and honestly very revealing, move. Instead of doubling down on the old tax justification, the government's briefing in Texas pivots. It says, in effect. Fine. Even if the revenue is minimal or zero, the NFA is still valid because Congress has other powers. They point to the Commerce Clause, which allows Congress to regulate interstate markets, and to the Necessary and Proper Clause, which allows Congress to pass laws necessary to carry out its enumerated powers. Under that theory, the NFA doesn't have to be defended as a tax at all. It can be defended as a federal licensing and record-keeping system for items that move in commerce. If that argument sticks, it has two consequences. First, it rescues the NFA from the problem Congress just created by cutting the tax. Second, it potentially gives the federal government a much broader foundation to build similar registries or licensing schemes in the future, even when there's no meaningful tax attached, from a Second Amendment, small government perspective. That's the nightmare scenario. The story changes from this is just a weird old tax law from the 1930s to Washington can build permanent registries for anything it decides affects interstate commerce. That's why groups like GOA are treating this case as an existential fight, not just a technical squabble. Now, that's one front in the war. The other front is thousands of miles away, in Hawaii, and that's where things get strange. To understand the Hawaii piece, we have to layer in the Supreme Court's Bruen decision. In 2022 in New York State Rifle and Pistol Association v. Bruen, the court said, very clearly, that ordinary law-abiding Americans have a constitutional right to carry handguns in public for self-defense, and that modern gun regulations have to line up with the nation's historical tradition of firearm regulation. Bruen knocked out New York's May-issue system and sent a warning shot to every other state that was playing games with carry permits. Hawaii got that message, at least on paper. It shifted from a may-issue regime to a shall-issue framework, meaning if you meet the objective criteria, the state has to give you a permit. But at the same time, the legislature went to work trying to claw back as much ground as possible through so-called sensitive place restrictions and a brand new rule on private property. That private property rule is what people are calling the vampire rule. Under Hawaii's law, if you have a carry permit, you are presumptively banned from carrying your firearm onto most privately owned property that is open to the public, such as stores, restaurants, and parking lots, unless the owner gives express permission. In practice, that means you need some sort of explicit guns allowed sign or a clear, individual green light. No invitation, no carry. Just like the old vampire stories, you can't come in unless you're invited. Gun owners in Hawaii, along with gun rights organizations, challenged that and other parts of the post-Bruen law in a case called Wolford v. Lopez. At the trial level, the district court agreed that this default ban on carry across essentially all private property open to the public went too far. The judge applied Bruen and said, there's no historical tradition of the government imposing this kind of blanket rule and forcing property owners to opt into your rights. But Hawaii appealed, and the case went up to the Ninth Circuit. And if you follow Second Amendment litigation, you already know the Ninth Circuit's reputation. In its opinion, the panel sided mainly with the state. It allowed the vampire rule to stand, treating it as just another reasonable way for the legislature to regulate where guns can be carried. Even after Bruen, that might have been the end of the story, except the Supreme Court stepped in. The plaintiffs asked the justices to take Wolford, and the court granted review. So, now, one of the core questions on the table in Washington is whether a state can effectively hollow out the right to carry by flipping the default on private property, making carry illegal almost everywhere unless each owner goes out of their way to say yes. Here's where the plot twist hits the Department of Justice. The same DOJ that is fighting to save the NFA in Texas filed an amicus brief at the Supreme Court in Wolford v. Lopez, siding with the gun owners. In that brief, the federal government tells the justices that Hawaii's vampire rule goes too far. It warns that if states can make carrying illegal on virtually all private property that's open to the public, they can effectively nullify the right that Bruen recognized without ever saying so outright. In other words, DOJ is saying, you can't comply with Bruen on paper and then take the right away in practice by declaring the entire modern world a gun-free zone unless there's a welcome sign on the door. That is not a small thing. The United States government almost never files pro-Second Amendment briefs on the side of the individual. And yet here, in this narrow but important context, it is telling the court that Bruen has real teeth and that Hawaii crossed the line. Put these two stories side by side, and you start to see the tension. In Texas, The DOJ is stretching every constitutional lever it can reach. Commerce, necessary and proper, to preserve a federal registration scheme that no longer collects tax money on most of the items it regulates. It is doing everything possible to make sure the NFA survives this new challenge. In Hawaii, DOJ is telling the Supreme Court that a state cannot use clever drafting and default rules to wipe out the right to carry that Bruen confirmed. It is, at least in that setting, asking the court to enforce the Second Amendment against a hostile legislature and a friendly lower court. So, what do we do with that? What does it mean for you, as a gun owner, that the same agency is defending a nearly tax-free federal registry in Texas while attacking a state-level carry ban in Hawaii? When you step back from the details, the picture is clear. The next phase of the Second Amendment fight is about who holds the power over your rights, on what theory, and where the courts finally draw the line. That's the field we're on now, whether Washington likes it or not. All right, Patriots, before you head out, do me one favor, hit like, pound that subscribe button, ring the bell, and stick around with this channel so we can keep watching over our rights together. God bless you, and God bless America. I'll see you in the next one.